Hey, it's Uncle Dan, the lawyer man here, coming to talk to you about everybody's current favorite subject, which is Fender, and Fender's recent threats against builders of Strat-style guitars, which this isn't. This is, though, a kind of offset style of guitar. It's beautiful. Sorrento. Anyway. It's all in the news that Fender has been threatening to sue various American makers. LSL Guitars is the one that's most in the news now for building Strat-style guitars, and they have sent a cease-and-desist letter basically a cease-and-desist letter to LSL. LSL hired a lawyer, Mr. Ronald Beinstock, out of Fox Rothschild, and Fox Rothschild, on behalf of LSL Guitars, has apparently responded. I believe it was LSL Guitars has responded. Tone Nerds has done a great job of reviewing the letter. They got a redacted version of the response letter. I'm not sure why people are being a little coy about this. Phil Knight showed some pages, showed portions of pages from Fender's cease and desist letter, and the Tone Nerds quoted extensively from Beinstock's long and excellent letter in regard to the matter. I want to chat about it a little bit. I am a practicing lawyer, licensed in the state of Washington. I was actually formerly a partner with Fox Rothschild, where Mr. Beinstock works, although I worked out of Seattle and he's out of New Jersey, and I never knew him. I only worked there a while. I worked for another firm, Riddell Williams, out of Seattle, and it was acquired by our friends at Fox Rothschild, and I retired for a time shortly after that, and then unretired, and I'm back in practice with a very small firm. Anyway, I thought I'd comment on a few things because I'll try to make them a little simpler and a little better. I saw a guy named, well, I won't say his name, but I saw another lawyer, guitar playing lawyer, who talked about it, and he basically said some things that were incorrect, and I wanted to talk about a few things. First, let's go back to what Fender has in its hand. Back in March or something like that, Fender got a default judgment against a Chinese manufacturer in a court or a tribunal of some sort. I'm not sure whether it was a court judgment or what. I haven't seen that document. But anyway, they got a default judgment against a Chinese manufacturer in Düsseldorf, Germany. And it has been trotting that around now and trying to use that. Now, about that default judgment, what it got was a default judgment stating that the body shape of the Stratocaster is copyright under EU law. Now, not under U.S. law, but it's copyright under EU law. But all it has is a default judgment against that one entity out of that one court. Now, I am not familiar with EU law, and so I'm not going to say much about it, although Mr. Beinstock's letter apparently does address that. But Fox Rothschild has people it can go to and talk about EU law. I can't talk about EU law. Let's talk about the value, though, of Fender's default judgment in the United States. And the value of that is essentially nil. It might have some value against the Chinese manufacturer if the Chinese manufacturer showed up here and made itself subject to the jurisdiction of the U.S. courts. The Chinese manufacturer isn't going to do that. We can be sure of that. The Chinese manufacturer is probably entirely opaque as to who that Chinese manufacturer is. And it can just change names, I'm sure, and be another manufacturer. So I think that's just just a worthless argument on on Fender's, that Fender might have. As to anybody else in the United States, in any U.S. jurisdiction, that default judgment that Fender got in Düsseldorf, anybody sued in the U.S., that default judgment is worthless, and it's worthless for a variety of reasons. For one thing, it was not a judgment on the merits, which could be of some value. Under U.S. law, it would not be a judgment on the merits because it was decided on a procedural basis. It would have effect, again, if at all, only as to that defendant. It would not have any preclusive effect, as it's called, on any other potential, actual or potential defendant. And let's introduce you to a couple of concepts. One of these concepts, and I'll try to put a note into this effect. One of these concepts is called issue preclusion or collateral estoppel. Issue preclusion is a doctrine which says that basically, if an issue has been finally decided in a court of competent jurisdiction as to the party against whom it is sought to be used, that issue is sought to be used, and it's decided by a court, finally decided by a court of competent jurisdiction, then that decision on that issue in that court is preclusive as to any litigation of that issue in any other court. Let's say that it's decided, if it's decided in some court that Fender does not own, under United States law, a trademark in the Stratocaster body shape, and we'll come back to that later. It's decided it does not own a trademark in that body shape. Then, by golly, and that's finally decided in some court or tribunal of competent jurisdiction, then that decision will preclude Fender from arguing in any other U.S. jurisdiction that it can actually trademark that shape. So that would be have preclusive effect. That's called issue preclusion. It's also called collateral estoppel. You are stopped from doing something collaterally. That is not in the central action, but in some collateral or side action. So there would be what we've got with Fender with its. I'm sorry, I've got some legal documents around, but I should have had them. But anyway, Fender's got this document, but it has no preclusive effect has no issue preclusion effect, and can't have any issue preclusion or collateral estoppel effect on any other party in the United States, under United States law, as to any other party than potentially the Chinese manufacturer. And I think even there, because it was a default judgment, it wouldn't have issue preclusive effect. It would not have collateral estoppel effect against that manufacturer. So that's part of it. So that judgment, again, that judgment has, out of Düsseldorf, no issue preclusion effect in the United States as to anybody except perhaps that Chinese manufacturer. And even there, I don't think so. Against LSL, it would not have any preclusive effect. Then we get to the next doctrine, and it really doesn't apply here. It's called either claim preclusion or res judicata. And claim preclusion applies to say that basically, if you raise claims in one case and against one party, and you could have raised other claims in that case, then you probably related to that issue. Then you can't get them again. This typically shows up in like car wreck cases and stuff like that. You have a car wreck and you come in and you say, hey, you know what, you wrecked my car, and you lose on that. You come back and say, hey, guess what, you also wrecked my guitar that was sitting in the car. And the court will say, hey, look, you could have brought that claim in the original case. So that has a preclusive effect on it. But it has to be between the same parties. The decision, there has to have been a decision on the merits, and probably a couple other things, but I'm blanking on those right now. Anyway, because there's no, Fender wouldn't be using this against, the Chinese entity in the U.S. as far as I can tell. So there wouldn't be any claim preclusion. It might have an issue too, by the way, because of a difference in U.S. law and also some other things. So the EU, as far as I'm concerned, that EU order or judgment that Fender's trotting around means absolutely nothing in the United States, and I don't know why Fender would trot it around and try to say that it does. Again, I'm not opining as to EU law, so that's that. So no value there on that. What other value could it have? And I just can't think of any. So a couple things about Fender. We know that they lost again in the trademark. They lost a trademark action in 2009, and Mr. Beinstock was actually attorney for the prevailing parties of that. Fender lost a trademark action there, which said that they tried to trademark the body shape of the Strat, and the U.S. Trademark Board said, "Nah, you can't. You slept on your rights too long." It's called typically the doctrine of laches, L-A-C-H-E-S, and it means you can't just sit around and watch people do stuff for a long time and then say, "Hey, you know what? You've been doing that forever. I'm going to sue you now." You can't. And so Fender watched for decades as other people manufactured and sold Strat-shaped guitars and called them Strats and Super Strats and things like that, or S-style guitars. And Fender didn't do anything about it and didn't slept on its rights. So the court said, yeah, maybe it could have been a trademark at some point, but sure as heck lost it eventually. So now that is, we talked about issue preclusion. That is an adverse ruling against Fender that can be used against Fender in any later case. Yeah, hey, you tried. You can't get any trademark protection on that. So the trademark board just shot that down. So Fender can't get a trademark claim there. So can it get do what it can't get a patent because it did have a design patent on at least the precision bass design, which is basically the same design as the Strat, but that expired, I don't know, back in the 60s. So that patent has expired, and if Fender tried again on that, well, they can't patent it now. I mean, it expired. In any event, it's out in the market and been out in the market too long. They can no longer patent that, so they don't have a patent. That takes us to the third prong of IP, intellectual property, and that is copyright. And that's what Fender used in the EU. And they are claiming, you see, EU law, European Union law, is much more generous on copyright than U.S. law because it will let you come back and claim copyright, many years later. Fender put this out, put out the guitar, 1954, and never claimed copyright on it, and also, clearly let the trademark rights, which are different but related, but let those lapse. Or, if it ever had the trademark right, and I think it did early on, it had a right to trademark it, but it never did, never protected that right, and so heck with you. Fender, as far as I'm concerned, I gotta stop this and restart it. So back to our friends at Fender. in regard to copyright, the Fender faces some other issues, and if you watch the Tone Nerds, Mr. Beinsock addressed those very thoroughly, and I'm just sitting here talking off the top of my head. They have a problem. You can't copyright, functional designs, so that you, if something is present just to be functional, you can't claim that there's no copyright available in it. So that on a guitar you can't you can't copyright the fact that it has a neck and and strings and frets, and for an electric guitar you can't copyright the fact that it has pickups, right? Because those are functional. You might be able to, if you can separate the functionality from the design, you may be able then to copyright it. Sometimes people do that. They can do that. And there are some things, actually I have a Meteora over here, but I forgot to pick it up. I'm not going to grab it now. But Fender might have been able there to copyright some of the Meteora, although I kind of doubt it. Fender really shot themselves in a couple of ways. First, they never claimed the copyright. It's been too long now to claim the copyright, and they also basically used to say, "Hey, this is all entirely functional." This has a little bit of a contour. These contours here. This has a contour on the back. These contours here on this. These are functional. They're for the comfort of the player. This is for access to the guitar. This is. And it's hard to hard to copyright, the basic kind of shape of a guitar, because, you can maybe see that old, it's actually almost new. It's only a couple of years old, that guitar sitting in the background there, which is an arch top based on, that's been around, that design's been around forever. So the idea of a musical instrument having a lower bout waist and an upper bout, I don't think you're getting that. So none of those things is protectable for Fender. So Fender, I think, shot themselves in the foot, because they said all these things were functional. So you can't copyright those. By the way, Fender did have some, patents, like and it's a vibrato or tremolo system that it had come up with. So all of those, I think, are. I just think it can't copyright those. And then Beinsock points out that in the EU case, Fender claimed that Leo Fender had created the design of the Fender Stratocaster, when the Fender website says other people, Tavares, Freddie Tavares, I think I'm blanking on the first name, Fullerton and others had input into it, so that makes it work, not a single artist's work, but a corporate work, which it created problems. Finally, the last thing that I see Fender has asserted and has a trademark, although I don't think they should have gotten a trademark in the shape of the headstock. This old Sorrento, which is late '60s, early '70s, something like that, probably manufactured by Kawai. This is not a Fender shaped headstock. But Fender, as far as I'm concerned, Fender kind of stole the design of that headstock from Paul Bigsby, but there was a case in the '60s where Bigsby tried to I don't know whether he tried to get a patent, get a design patent, or get a trademark or what on that design, but maybe a design patent. But Fender fought that and said, "No, that goes back to much older instruments that six on a side and the kind of truncated scroll that you get there. That's a that goes back. So I don't know how Fender can claim that. And also, as for Fender's been policing it to some extent, but boy, I think they slept on their rights on the headstock too. There are just tons of competing products out there with identical headstocks. And Fender, I don't see how they can claim a copyright in it too. One thing, if you got a copyright, it's got to be fixed, not just an idea. You can't copyright an idea. So just the idea of a guitar with this, in this case, a somewhat offset shape. This was clearly influenced by the Jazz Master. You can't copyright the idea of an offset guitar. You can't copyright the idea of a guitar shaped like the Strat. And then the Strat Strat body shapes have varied over time. Actually, Mr. Weinstock in his letter said the old ones were hand sanded. They were cut out. I guess probably cut out on big band saws and then hand sanded. And the body shapes varied hugely, and contours varied a bunch, and so you don't have anything that's a fixed expression, and it's hard to you got a whole bunch of these things that are all a little different. So anyway, I think Fender's got a bunch of garbage arguments, and I think that they're just trying to bully these smaller makers. I hope they lose, and then, man, I don't know. There's I used to know the number off it very well, but there's a unfair competition law out of California, Business Profession Codes 12100, 12700. I'm blanking on it. Anyway, the unfair competition law out of California. Boy, I don't know. I think that some smart plaintiff's attorney in California might try to find a way to claim that these cease and desist letters out of Fender are violating that. Anyway, my take, this sort of thing seems to me, had Fender trademarked it, been aggressive with the trademark, the trademark of the body shape from the beginning, yeah. But they went to sleep too long. And if you do that, whatever sympathy we might have had for them from the beginning. I've heard people say, "Oh, go out and come up with your own designs," and yeah, okay. But when you've let this go for decades, and people have built businesses out of copying your designs, and you just slept on it, don't come around now and say, "Oh, hey, you stole my design." That's again, you slept on it. You slept on your rights, and we routinely, say, "Hey, if you sleep on your rights, you'll lose them. Use them or lose them," and that's what happened to Fender. So anyway, and I got no sympathy for him, I've been thinking about buying a twin reverb Tone Master. I'd kind of like to have something really loud but not really heavy, and been thinking about buying a Tone Master, and I'm thinking maybe I won't, Anyway, Uncle Dan, the lawyer man. You got any questions, let me know. Take care and bye now.